Judge, I have, I think, probably 4 witnesses that I want to call.
Okay, do you want to make any pre-hearing motions by either one, or do you want to make an opening statement? I know it's not a trial. Anything, I just start calling witnesses. You may.
Yeah, let me just, not really by way of argument, but sort of summary as to what we're involved with is, I think it's critical for evaluation of a constitutional issue, particularly a First Amendment issue, that we talk about some things, especially since the city has raised some defenses. So what I think these folks hopefully will explain to you is sort of what this Occupy Tucson event and assembly and group is about. What's their message? How are they organized? How's that message transmitted? How's it understood by the public? Why? Because the city is trying to assert a rule that says, boom, at 10:30 at night, you can't be there until 6 in the morning. Why that's useful and effective for the organization. You know, that sort of stuff, because the First Amendment issues relate to the message that's going out to the public. Is the public receiving the message, and why are they doing it, and how they organize? Because authentic First Amendment expression, authentic assembly has an important role. Obviously, that's at the top of the list with our message.
I'll interrupt you, Bill. In this particular case for the court to determine more on the assembly side rather than limiting any speech at all?
Well, I
understand they probably go together in that particular case. I mean, you assemble, have speech, and express yourself, whatever your feelings are and your beliefs. But with the regulation of the park, is the big issue, does the city have the authority, the safety, health, and welfare, or some sort of issue, to restrict the use of the park for a certain time with reasonable notice and legitimate legal reasons? Isn't that the issue?
No.
Okay.
That's
okay.
You know, that's not the issue.
Okay.
And the reason that one of the reasons why that's not the issue is if you take a look at the city ordinance, which is attached to the motion to respond to the city. They've attached the ordinance, and they've attached some minutes of what happened at the mayor and council meeting. And everything in that ordinance relates to, if you look at the kind of events that happen in the park, they relate to picnics in the park, serving beer in the park, certain entertainment, all that kind of stuff. There's absolutely nothing in there that relates to political uses or political expression. Well, yeah, because they, all these cases will talk about how if it affects your First Amendment rights and assemblies, you have to narrowly draw the statute. They use the term narrowly tailored. So my argument is, this thing isn't tailored, let alone narrow. What they've done is, my analogy, it'd be like sometimes maybe the government says, here's a drug you can use for this disease. And then somebody else is prescribing, trying to use it for something totally different. They've created some rules for a variety of uses in the park, but none of them relate to or at all to political activity. And they rely, for instance, on this Clark case with the U.S. Supreme Court and the National Mall, and the park's got a bunch of rules that all relate to politics that narrowly drawn because they have demonstrations there all the time. So I think it isn't an issue of like, could the city draw up ordinances in the park that relate to certain political uses that are narrowly tailored that can affect First Amendment rights and stuff. Because I actually don't think they've done it in this case. One of the witnesses, I think, can tell you that Dick Kaiser was participating with the Occupy group and the city where they were trying to frame an ordinance that would deal with this sort of thing, deal with political activities in the park. This one